What is public interest litigation? Public interest litigation is a means of constitutional litigation involved in India under the writ jurisdiction of courts designed to realize fundamental rights and human rights of the vulnerable and disadvantaged sections of society. Conceived as part of the legal aid movement in the early 1970s, the focus of public interest litigation, or PIL as it's commonly known, is not the vindication of private interests but of collective diffused rights. The Supreme Court evolved this instrument to make the constitutional mandate under Article 32 more meaningful by allowing the demand for the rights of the poor to be voiced through any public-spirited person. The need to relax the traditional Anglo-Saxon form of adjudication was what was felt by the Supreme Court, which motivated it to evolve the system of public interest litigation. So, like I said, the objective of this module is to provide a compact overview of public interest litigation by focusing on the following aspects: the purpose of PIL, the procedural flexibilities introduced, the broad phases of development of PIL, and the positives and problems as has been seen over the years in PIL. So this is what the lecture will focus on. The need to relax the Anglo-Saxon form of adjudication was best expressed in S.P. Gupta versus Union of India, a seminal judgment in PIL jurisprudence, where, to quote the Supreme Court, what the court said is that the court has to innovate new methods and devise new strategies for the purpose of providing access to justice to large masses of people who are denied their basic human rights and to whom freedom and liberty have no meaning. The only way in which this can be done is by entertaining writ petitions and even letters from public-spirited individuals seeking judicial redress for the benefit of persons who have suffered a legal wrong or a legal injury, or whose constitutional or legal right has been violated, but who by reason of their poverty or socially or economically disadvantaged position are unable to approach the court for relief. So this is what the court felt was the need to motivate and to develop a system of public interest litigation. The court also noted how procedural technicalities were watered down in the context of PILs in the United States, which is the birthplace of PIL, and in the United Kingdom. In the Indian context, the court observed that the increasing employment of law as a device for orchestrating socio-economic development has resulted in the emergence of collective rights and social action. In this environment, individual rights are meaningless unless accompanied by the social rights necessary to make them a reality. The consequence of such socio-economic rights is that the state now owes a duty to the larger public. In other words, violation of such rights causes public injury as opposed to the individual injury. PIL petitions can be filed in the Supreme Court under Article 32 to enforce a fundamental right, and before a High Court under Article 226 to enforce a fundamental right or any other right. Having given an introduction to what PIL is, we will now move to understand the various flexibilities which have been introduced and developed by the courts to really allow PIL to develop and grow. So we will be focusing on flexibilities in standing, form and evidence. PIL has entailed significant innovations spearheaded by the Supreme Court, which have diluted the adversarial stronghold on judicial proceedings. The first such innovation is expansion of locus standi. In the adversarial system, only the person who has directly suffered the infringement or violation of a right can approach the court for redressal. However, the whole premise of PIL is to facilitate litigation in the interest of the larger public to preserve and vindicate collective rights. If the traditional rule of locus standi was adhered to, then public grievances could obviously not have been brought before courts by any individual. Therefore, expansion of this rule was a sine qua non for the evolution of PIL and any public participation in judicial administration. This need was even more urgent in a country like India, where a huge proportion of the population was denied access to the judicial system on account of illiteracy, indigence, and ignorance. Realizing this need to enforce the rule of law and particularly secure justice to disadvantaged sections of society, the Supreme Court expanded the ambit of locus standi, empowering any public-spirited person acting bona fide and having a sufficient interest to approach the court for redressal of a legal wrong, even if his right was not violated or infringed in any manner. Accordingly, non-governmental, non-profit, voluntary organizations, advocates, medical practitioners, and journalists have initiated PILs. For example, the landmark Husainara Khatun cases, which brought the right to speedy trial within the fold of Article 21, started with an article written by a journalist in the Indian Express. The journalist highlighted the plight of under-trial prisoners languishing in prisons in Bihar for many years beyond the sentence period, following which an advocate initiated a PIL under Article 32. Courts, however, have been cautious to not liberalize the concept of locus standi in criminal and service matters wherein the private interest has been reinforced to deny frivolous petitions. The second innovation has been the development of epistolary jurisdiction. The interpretation of appropriate proceeding in Article 32 as referring to only the purpose and not form of the proceeding facilitated the development of epistolary jurisdiction, wherein the court takes cognizance of writ petition filed in the form of letters and telegrams. Many landmark PIL cases found their way to the Supreme Court through letters. The acceptance of such cognizance was reasoned by Justice Bhagwati in Bandhua Mukti Morcha on the ground that it is not right or fair to expect a person acting pro bono publico to incur expenses out of his own pocket to approach a lawyer and prepare a regular writ petition. In response to the objection of gross impropriety in the petitioner choosing the presiding judge himself, the Supreme Court issued a set of guidelines to be followed for entertaining letters or petitions received by it as PIL in 1988, specifying permissible letter petitions and matters which will not be admitted as PIL in any form. The guidelines also lay down the procedure by which petitions will be screened by the PIL cell and then placed before the presiding judge to be nominated by the Chief Justice of India. However, the legitimacy of epistolary jurisdiction has time and again been challenged as facilitating unnecessary and frivolous litigation. The third innovation has been the aid in evidence. The Supreme Court responded to the challenge faced by weaker or disadvantaged sections of producing relevant material and evidence by relaxing adversarial norms governing evidence and evolving suitable remedies. In support of this concession, the court has consistently emphasized that PIL is not an adversarial but a collaborative and cooperative process in which all concerned parties should work together to realize the rights of deprived sections of society. In the words of the Supreme Court, there are no winners or losers. Conscious that fundamental rights and human rights would be rendered illusory by a passive attitude, the court has appointed fact-finding commissioners such as expert bodies, professionals, and bureaucrats to gather facts and data. The commissioner's report furnishes prima facie evidence of the facts and data. The court retains the discretion to determine the extent of its reliance upon the report. Another innovation has been the appointment of amicus curiae to prevent PIL litigants from being unfairly prejudiced. The court may be better assisted by a lawyer who comprehends the legal dimensions and implications of the issue and approaches the cause objectively and dispassionately. The role of amicus curiae has been significant in the prosecution of PILs. The court has also assumed creeping jurisdiction, equipping it to issue appropriate interim orders and directions. The fourth innovation has been the liberal interpretation of Article 21. A major impetus to the PIL movement was supplied by a liberal and expansive interpretation of Article 21, which emerged as the most fertile provision to evolve new fundamental rights, such as the right to health, shelter, free and compulsory education up to 14 years of age, and speedy trial, to only name a few. This was significant in enhancing the popularity and success of PILs, since many of these rights were read into Article 21 as an outcome of a public interest litigation. Notwithstanding these beneficial innovations for petitioners, courts have consistently emphasized that PILs cannot be actuated by selfish or personal motives to further private ends, or by malice, or by political or oblique considerations. Petitioners must be acting bona fide with a view to vindicate the cause of justice. Further, they have been restrained from abandoning petitions during proceedings, as they are expected to be conscious of the obligation being exposed and to accordingly conduct themselves. We will now move on to understand the various phases in the development of PIL. PIL can broadly be divided into three phases. The first phase is known as the engine of social change. In the first phase, which began in the late 1970s and continued through the 1980s, PIL was used as an instrument for social transformation, wherein the judiciary recognized the rights of marginalized sections such as bonded laborers, prisoners, child laborers, and pavement dwellers, and directed the government to redress alleged violations. Cases were predominantly filed by public-spirited persons such as lawyers, journalists, social activists, and academics seeking relief against the action or inaction or non-action of executive agencies resulting in violations of fundamental rights. The second phase is known as the phase of institutionalization. In the second phase, which was in the 1990s, PIL became more institutionalized in terms of the litigants and breadth of issues. Several specialized NGOs and lawyers started bringing matters of public interest on a much regular basis. The breadth of issues also expanded tremendously, ranging from environmental protection, sexual harassment at the workplace, right to education, to good governance and general accountability of the government. Relief was not only sought against executive agencies, but also against private individuals in relation to policy matters. The response of the Supreme Court was much bolder and unconventional as compared to the first phase, and surpassed the declared objective for which PIL was meant. The Supreme Court engaged in judicial legislation to fill legislative lacunae and enforced fundamental rights against non-state actors, a prime example being Vishaka versus State of Rajasthan, where the Supreme Court laid down guidelines governing sexual harassment at the workplace. Non-compliance with judicial directives was taken much more seriously, and the Supreme Court did not hesitate to monitor government investigative agencies and or punish civil servants. This forwardness or this activism of the judiciary, however, furnished the breeding ground for the misuse of PIL, which reached disturbing levels in this phase, occasionally compelling the court to penalize plaintiffs for employing PILs for ulterior purposes. The third phase is the phase which has raised the question of whether public interest litigation has really become private interest litigation or publicity interest litigation. In the third phase, which began at the turn of the century, misuse of PIL has become seriously acute, raising serious questions about its true purpose and attitude of the judiciary. There has been an unforeseeable expansion of issues raised, including absolutely trivial issues, such as calling back the Indian cricket team from Australia and preventing an alleged marriage of an actress with trees for astrological reasons. In contrast to the first two phases, it has been argued that the judiciary has shown more restraint in issuing directions to the government and has been influenced by development and free market considerations in favor of the government. This is seen as coming at the cost of the sympathetic response that the rights and interests of vulnerable sections received in the early years, and indicative of undesirable changes in the judicial philosophy on PIL. We will now proceed to examine the positives and problems in PIL. We will first begin with the contribution of PIL. The emergence of PIL has undoubtedly been a salutary development in making the constitutional guarantee of fundamental and human rights a meaningful reality for vast majority of citizens most deprived of them and having otherwise limited or no access to justice. It has also been a powerful tool in establishing many important socio-economic guarantees, whether it be education, health, shelter, livelihood, among many others, enshrined in the non-justiciable directive principles of state policy as fundamental rights, at least in theory. Through PIL, the judiciary triggered legislative reforms and filled legislative lacunae in important areas through guidelines which are in consonance with the mandate of the Constitution and several international covenants ratified by India. This has enhanced sensitivity to critical issues and public confidence in the judiciary as being receptive to social realities. Beyond Indian frontiers, the PIL jurisprudence has also had a transjudicial influence on judicial dialogue, wherein courts of South Asian countries such as in Hong Kong, Bangladesh and Sri Lanka have relied on Indian PIL cases to develop their own PIL jurisprudence. But now, from judicial activism to judicial adventurism, the question is, where do you draw the line? Over the years, the PIL project has amplified much beyond its original conception, giving rise to legitimate criticism that its true purpose has been lost sight of. The overzealousness of the judiciary in overstepping its jurisdiction has been attacked for ridding this instrument of much of its credibility and for encouraging petitioners to file frivolous cases. Petitioners have approached courts for all sorts of issues, such as to regulate the treatment of wild monkeys in Delhi, to impose a ban on objectionable photographs in newspapers, and condemn the practice of conducting school admission interviews for children. Unfortunately, courts too, especially the Supreme Court, have taken many petitions to their logical conclusion, which have not involved a question of fundamental rights, but rather issues like regulation of traffic, arbitrary allotment of petrol outlets, investigation of alleged bribe-taking, and most recently, the authorization and legality of e-rickshaws in Delhi. Such issues can somehow be brought within the ambit of Article 21, given its liberal interpretation. However, the propriety of this is seriously questionable, especially given that the Supreme Court was conceived as a constitutional court. From the judiciary's point of view, it can be demanded that it is time for judicial introspection, given the more than apparent dark side of PIL, the primary problems of which will now be summarized. The first problem is the ulterior purpose problem. Although the Supreme Court has emphasized the need for circumspection in PIL, in practice it is arguable that courts have not rigorously enforced the public interest requirement and have allowed the public to be substituted by private or publicity. As demonstrated in the lecture, almost any issue is presented to courts in the guise of public interest to take advantage of the benefits of PIL, such as the less expenses, the quick response, and the high impact. Although the distinction between public and private is not always clear, it would be safe to say that courts have contributed to this abuse of process to a very large extent. Ashok H. Desai and Justice Muralidhar confirmed the perception, and to quote them, that PIL is being misused by people agitating for private grievances in the garb of public interest and seeking publicity rather than espousing public causes. The second problem is the disturbance to the constitutional balance of power. Although the Indian Constitution does not prescribe a strict separation of powers between the three organs of government, it still follows a system of checks and balances. The independence of the judiciary stems from this very embodiment, and thus it becomes important for courts to respect the system. However, through PILs, courts have adopted an activist mode and encroached upon the domains reserved to the executive and legislature through various means, such as prescribing policy through guidelines, taking over governance and monitoring executive agencies. The blurring of the distinction between law and policy can be illustrated through some prominent cases decided by the Supreme Court, where in one case the court directed the central government to indicate the steps taken for environmental policy and place the same before any national environmental protection policy. In another case, the court constituted an expert committee to examine the depletion of forest cover, imposed restrictions on the felling of trees and sale of timber, and issued a continuing mandamus to closely implement its orders. In another case, the court readily laid down guidelines which were to be enforceable till such time the legislature enacted a law in compliance with an international convention. And then in another case, the court laid down the procedure to be followed by the police to arrest a person. However, courts have selectively cited the policy argument to intervene or refrain from intervening in policy questions with no discernible basis for such selective intervention. To illustrate, the judiciary has intervened to tackle sexual harassment, custodial torture, and adoption of children by foreigners, but has stayed away from issues like the introduction of the Uniform Civil Code, the propriety of the government's telecommunication policy, and the recognition of a particular language as a national language. Having said this, Ashok Desai and Justice Muralidhar observe that the dominating trend has been for courts to assert their new role as policymakers. This activism of the judiciary has been complemented for bringing to light the accountability of the executive and the legislature. However, the converse perspective is that the activism may in fact make these institutions more unaccountable and complacent because they know the judiciary is always there to remedy their failures. The need to act with circumspection has been recognized by judges, and Justice Pathak is known for famously voicing his concern on this front in Bandhuwa Mukti Morcha. The third problem is the strain on limited judicial resources. The liberal resort to PILs has compounded the huge backlog of cases languishing in the dockets of the Supreme Court and High Courts. By allowing frivolous PIL plaintiffs to waste the time and energy of courts, the judiciary may in fact be compromising legitimate private interests of other litigants and violating their right to speedy trial. A related problem is that courts generally take considerably long in disposing PIL cases, reducing their significance to probably one of academic value. The fourth problem is symbolic justice. Although courts have invested considerable resources in disposing PIL cases, a criticism raised is that the justice meted out is more notional than tangible. The optimists, however, would dismiss this as a problem, saying that something is better than nothing and that at least the judiciary has taken the initiative to compensate for the incompetence of the executive and legislature. However, the pessimists would consider this a problem in two respects. One, that courts have not been able to ensure the implementation of their guidelines and directions, and that judicial intervention has not really improved status quo significantly. And two, that the over-conversion of directive principles to fundamental rights has duped disadvantaged sections into believing that justice has been done to them. It is one thing to recognize rights, but another thing to provide exactly for their enforcement, and that by concentrating only on the former, the PIL project has devalued the very notion of rights by creating rights which cannot be enforced. The fifth problem is judicial populism. Judicial populism is an academic explanation wherein it is feared that PIL is used by judges to acquire popularity among masses as crusaders of rights, resulting in leniency in admitting petitions. The converse has also been cautioned against, that the desire to become people's judges in a democracy should not hinder admitting petitions which involve an important public interest but are potentially unpopular. These problems have not escaped the judiciary. The Supreme Court and High Courts have endeavoured to send strong messages on a case-to-case basis whenever they notice misuse of the machinery. In some cases, petitioners have been fined for filing frivolous petitions. On a few occasions, the Supreme Court has expressed its displeasure on how High Courts have admitted PIL petitions. In addition, one systematic step the Supreme Court took was to compile the previously mentioned guidelines governing letter petitions in 1988. However, the rather broad ambit of the guidelines renders their utility doubtful. The PIL cell has been entrusted the task of screening letters or petitions as per these guidelines and then placing them before a judge to be nominated by the Chief Justice of India. In order to check the broad ambit of epistolary jurisdiction, the guidelines were amended in 2003 to provide that an affidavit should accompany the statements in the petition whenever it is not too onerous a requirement. A failed attempt at regulating the misuse of the instrument was the Public Interest Regulation Bill in 1996, which was introduced in the Rajya Sabha but could not receive the assent of all political parties. However, despite these attempts and efforts, courts continue to be plagued by frivolous petitions. In the recent past, the Supreme Court has regularly expressed its frustration at the nuisance created by PIL and has called for the imposition of a penalty on malafide petitioners. Notwithstanding the judiciary's contribution to amplifying PIL beyond its original boundaries, one must be sympathetic to the difficult position too. As the guardian of fundamental rights, it is not easy to demarcate a dividing line between genuine and frivolous PIL cases. This probably explains the open-ended nature of the 1988 guidelines and the exclusion of PIL from the Supreme Court rules. As has been observed, given that the very premise of PIL is based on flexibility, it is not easy for the courts to keep the door open and at the same time stop busybodies at the gate. It would be fitting in the end to advert to some thoughts expressed by Justice Muralidhar and Ashok H. Desai in their article. They note that notwithstanding the criticisms and concerns regarding PIL, which are legitimate in their own right, it cannot be denied that the far-reaching judgments in many PILs have exposed executive failings and provided much-needed direction to adopt mitigating and corrective measures. PIL has also fostered the development of legal principles such as the polluter pays principle, the precautionary principle, and the principle to award compensation for constitutional wrongs. Given its importance in making the Constitution a living reality for cross-sections of society, the criticisms must serve as a reality check to courts and judges to rein in the PIL discourse, which has expanded beyond its boundaries. In the words of the authors, in many ways, PIL imposes a burden on as well as poses a temptation for the judge. On the one hand, there is a desire to resolve the problems of society where laws are not seen to be enforced, particularly where the petitioner before the court is espousing a public and not a private cause. On the other hand, there is a temptation for a well-meaning judge to extend the law, if necessary, by a policy decision, departing ever so slightly from the trodden path. Thus, there is an interplay of enforcing the law, molding it by equity, while also responding to the perception of an imperial judiciary making history. The future of PIL will depend much on where the court strikes the balance between the law and its sense of history.